Good morning, one and all. I welcome all of you for joining us to our Ial webinar on nature and scope of writ jurisdiction by Honorable Sri Justice Akula Venkata Sesha Garu, Judge High Court of Andhra Pradesh. I give a brief introduction of Indian Association of Lawyers. This webinar program is launched by the Indian Association of Lawyers. Hence, I consider it necessary to give a brief introduction of the organization. The name of the organization gives an impression that it's a body of lawyers. It is not so. When the Indian Association of Lawyers came to be registered under the Societies Registration Act 11 of 1860 at Delhi, the members of the organization who subscribed their signatures to the Memorandum of Association comprise of Justice V.R. Krishnaiyer, Justice P.N. Bhagwati, Justice D.A. Desai, Justice O. Chinnapareddy, Justice E.S. Venkatramaya, Justice M.P. Thakur, and Justice Rajinder Sachar. Senior advocates like P.P. Rao, Shri K.K. Venugopal, Shri M.K. Ramamurthy, Jurist Madhava Menon, to name a few. Justice V.R. Krishnaiyer was the founder president of IAL from 1983 to 2007. The principal object of the Indian Association of Lawyers inter alia was to bring together lawyers, judges, jurists, law teachers, and law students to promote and strengthen endeavors for speedy evolution of democratic, socialist, and secular India, and to ensure social justice to the people of the country. I am extremely happy to inform that IIL has lived up to the objects enshrined in its Memorandum of Association. Seminars on important topics relating to constitution, criminal jurisprudence, labor laws, cyber laws, election laws, fundamental duties, secularism, etc. have been conducted in different parts of the country. I am also glad to inform that the 10th National Conference of IIL was held in Vijayawada from 22nd to 24 February 2020, and more than 1,000 delegates from all over the country participated. It is in view of this pandemic COVID-19, IIL may not be able to hold national or state level seminars, workshops in the near future. Therefore, in order to keep implementing and promoting the objects of IIL, the seminars of webinar series has been launched. We are dedicating this memorial webinar lecture to Honorable Justice V.R. Krishnaiyer. I'll give a brief description of our speaker, Sri Justice Akula Venkata Sesha Garu. Justice Akula Venkata Sesha Garu was born in the year 1962 in an agriculture and freedom fighters family at Bhimavaram, West Godavari district. He had his schooling and primary schooling in Bhimavaram, and he has done graduation in DNR College Bhimavaram and BL degree in Sir C.R. Reddy College, Eluru, West Godavari district. He has enrolled as an advocate on the Bar Council of Andhra Pradesh on 3/7/1987 and joined the chambers of Sri P. Rajgopal Rao Garu and also worked in the chambers of late Sri P. Rajarao Garu. He has actively practiced in civil, criminal, services, constitution, and almost other branches of the law. He had developed an independent practice with a short span of time and extensively dealt with a number of cases covering all branches of the law. He is deeply interested in philosophy, culture, music, and education. He worked as standing counsel for Municipal Corporation of Hyderabad and was a panel advocate for the State Bar Council and an advocate for the state of Andhra Pradesh in the suit pertaining to Polvaram project instituted by the state of Orissa in the Hon'ble Supreme Court. He is elevated as an additional judge of High Court of Andhra Pradesh and sworn in on 12/4/2013. He is appointed as judge of the High Court of Judicature at Hyderabad for the state of Telangana and the state of Andhra Pradesh and has assumed charge as on 8/9/2014. Now, I hand over the platform to Honorable Sri Justice Akula Venkata Sesha Garu, Judge High Court of AP, for his eminent words. Thank you.
Good morning, and my heartful pronouns to all the participants. First of all, let me introduce myself. I am Sesha Sai, JJP High Court. I am fortunate enough to get this wonderful opportunity to meet all of you through this webinar. At the outset, we need to be grateful to the organizers of this wonderful event, Indian Association of Lawyers. Before entering into the topic, it is my responsibility to say a few words about a great personality and a legal luminary, Sri Justice V.R. Krishnaiah, in whose memory this program is being organized. He dedicated his entire life for social justice and for upholding the constitutional values. The greatness of Sri Justice V.R. Krishnaiah, all of you know. He was successful not only in political life, but also in judiciary. Wherever he was, he fought for the rights of downtrodden and the backbone of our system, that is farmers and workers. He was also the champion of public interest litigation, and he made it a tool and made his mark as a protector and a savior of democratic values in our country. Another greatness about him is he was the only judge in our Indian judiciary on whom the scholars submitted theses for PhDs in 3 different universities. In this context, it may be pertinent to say one thing. Another legal luminary, Sri Justice Chinnapareddy, Judge Supreme Court of India, he wrote a book, he authored a book, The Court and the Constitution. In that, about Justice Krishnaiah, he said, I quote, "Great judges, of course, there were many. Of all the judges who were on the benches of the Supreme Court, Justice Krishnaiah was undoubtedly the most creative, with a bleeding heart for the underprivileged, for the workers and the exploited, and for everyone who needed kindness and generosity." End quote. Authoring the books was his passion. He authored more than 100 books, exactly 105 books he authored. Let us begin this program by saluting to such a versatile personality, and by quoting his words from his book, Centenary Miscellany at Law. While referring to the pious duty of the bench, he said, the accountability to hear the cases is a fundamental duty, and the judge's duty is not a matter of pleasure or frivolity, but of a very serious gravity and not arbitrary, according to the will of the judges. To hear the cases before them and to pronounce judgments is a mandatory obligation on the judges. Unquote. Today, I have been called upon to share my thoughts on the topic nature and scope of writ jurisdiction. This topic, selected by the organizers, though not a new one, is undoubtedly of immense importance and significance for all the times. At the outset, we are very much indebted to another great son of this soil, Bharat Ratna, Dr. B.R. Ambedkar, the architect of the Constitution and the man behind this great document. In my view, Constitution is a sacred document and the consolidation of all the values in Bhagavad Gita, Quran and Bible. All of you know that the Constitution is the mother of all laws, and any law made by the Parliament or the state legislatures should be in consonance with the provisions of the Constitution and should not be repugnant to the provisions of the Constitution. If they are repugnant to the provisions of the Constitution, they are void. All of you know the preamble of the Constitution, which says, resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all the citizens justice, social, economic, and political, liberty of thought, expression, faith and worship, equality of status and of opportunity, and to promote fraternity, unity and integrity of the nation. So the ultimate goal of the Constitution is to achieve these laudable objects. The next important aspect which we need to know and which we come across very often in our professional life is Chapter 3 of the Constitution of India, which deals with the fundamental rights. And this chapter is popularly called, all of you know, the basic structure of the Constitution and is the heart of the Constitution. Yes, these rights are guaranteed under Chapter 3. Then, when there is invasion of these rights, when there is infringement of these rights, what is the remedy for the citizens? Then how to enforce these rights? That is by way of writs. Then what is meant by writ? The literal meaning is an order of the court, High Court or the Supreme Court, directing an individual or an official or an authority to do an act or to abstain from doing an act. All of you know, these are extraordinary remedies. And under what circumstances these remedies can be applied? Where the ordinary legal remedies are inapplicable or inadequate. Then where are these remedies provided? Article 32 confers jurisdiction on the Supreme Court of India to issue writs, whereas such power is conferred on high courts under Article 226 of the Constitution. Then what is the distinction between these two? You may ask. Supreme Court issues writs when there is violation of fundamental rights guaranteed under Article Chapter 3 of the Constitution. Whereas the high courts are conferred with the power to issue writs under Article 226 when there is violation of not only fundamental rights but also for any other purpose when statutory rights are infringed. Therefore, the jurisdiction of the High Court is much wider. On this issue, these two judgments are relevant. AR 1950 Supreme Court 163, I repeat, AR 1950 Supreme Court 163, Rashid Ahmad versus Municipal Board. And the second judgment is AR 1954 Supreme Court 403, Himatlal versus State of Madhya Pradesh. In fact, the jurisdiction of the Supreme Court and the High Courts as regards enforcement of fundamental rights under Chapter 3 is concurrent. In this connection, this judgment may kindly be noted. 2016 2ALD 192. 2016 2ALD 192 Supreme Court, paragraphs 10 and 12 also. That is, in the case of Alagapuram or Mohan Raj and others versus Tamil Nadu Legislative Assembly and another. Then coming to various types of writ petitions. Broadly, there are 5 types of writ petitions. They are habeas corpus, mandamus, certiorari, prohibition, and quo warranto. There are 5. Habeas corpus, I repeat, habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Let us deal with them in detail, one by one. First type of writ is writ of habeas corpus. The expression habeas corpus is a Latin term, and its meaning is to produce a body. This writ is also called freedom writ, since it safeguards right to life as guaranteed under Article 21 of the Constitution of India. If the court comes to a conclusion that there is no legal justification for a detention, court can direct release of the detainee and can also award damages. The purpose of this writ is to protect the personal liberty of the person detained Then you may ask, who are the persons competent to move this writ of habeas corpus? The detainee, or on his behalf, friends and relatives, but not a total stranger. Unlike other type of writ petitions, writ of habeas corpus is a writ of right, not of discretion. Then, what are the purposes for which writ of habeas corpus can be issued? Number one, for enforcement of fundamental rights, if any arrest or detention is resorted to by the executive without the sanction of law. Second contingency is when the order of imprisonment or detention is ultra vires the statute. But under certain circumstances, it can neither be prayed nor granted. Those contingencies are when the person against whom the writ is sought or the person who is detained is not within the jurisdiction of the court. Second contingency is to secure the release of a person who has been imprisoned by a court of law on a criminal charge. Third contingency is to interfere with the proceeding for contempt of court, of record, or by parliament. Next contingency is to protect the society. The arrest is essential. In this context, you may get a doubt. Whether the doctrine of res judicata is applicable so far as the habeas corpus petitions are concerned. And this is an exception to the rule of res judicata. Supposing a petition for habeas corpus is dismissed by the High Court, when High Court is moved under Article 226 and is dismissed by the High Court, still the petitioner can move the Supreme Court under Article 32 of the Constitution. That's about the writ of habeas corpus in brief. Then coming to the second type of writ, which we come across in 90% of the cases, writ of habeas corpus. This expression mandamus is also a Latin term, which means the command of the order. And this is popularly called writ of justice. And it is an important writ to check the arbitrariness of an administrative action. Normally, we come across the aspect of locus standi, competence to move the court. The rule of locus standi needs to be followed strictly in the case of mandamus, except in PAS. And it is incumbent and obligatory on the part of the person applying for to show that he has the right to enforce public duty in his favor. Then, against whom the writ of mandamus can be issued. What are the various bodies? Government, semi-government, local bodies, and all public authorities and their actions against legislature, also in certain circumstances, and even against the actions of the High Court on administrative side. The decisions on administrative side can also be tested by way of this writ on administrative side. Then against whom it doesn't lie. All of you know the president and governors, excellency president, excellency governors, they have immunity from this under Article 361. Doesn't lie. Against a private individual or a body or a company incorporated under the Companies Act in the absence of element of any public duty. Since you come across this situation very often, there is one judgment of the Honorable Supreme Court which clarifies the issue. AER 1989, Supreme Court 1607. Repeated. AER 1989, Supreme Court 1607. Sri Ananda Mukta Sadgum Sri Muktaji so and so versus R. Rudam. This may kindly be referred to. Another important aspect is you may entertain a doubt. Whether a mandamus can be sought against legislature to enact a particular law and to prevent it from enacting a law. No, this can't be done. Another thing is, actions of high courts on judicial side cannot be subjected to writs. Supposing a writ petition is allowed or dismissed by a learned single judge of the High Court, wherever letters patent appeal is applicable, appeal lies under clause 15 of the letters patent to the division bench. That is the remedy. In this context, one more judgment of the Honorable Supreme Court is relevant. AR 1999 Supreme Court 3471. One class of people approached the court for a direction to the government to provide reservations. Supreme Court said, Honorable Supreme Court said, no, there can't be such direction to the government. Then an individual praying for a writ of mandamus needs to satisfy certain conditions also. First one is, there must be public duty on the part of the respondents, and such a duty must be absolute. There must be a legal right in favor of the person applying for, and there must be specific demand and refusal. Then these judgments are relevant in this context. AR 1969 Supreme Court 1306, repeat, AR 1969 Supreme Court 1306, AR 1962 Supreme Court 1210, repeat, AR 1962 Supreme Court 1210, AR 1952 Supreme Court 12, AR 1952 Supreme Court 12, AR 1978 AP 457. Last but not the least, AR 2002 SC, AR 2002 Supreme Court 1598. Then, the third type of writ is writ of certiorari. The word certiorari is also a Latin term which literally means to be certified. Under this jurisdiction, court can call for the records to verify the validity of the decisions of such authorities. If such decisions are found to be illegal, they would be quashed. You may entertain a doubt and ask, under what circumstances this type of writ can be issued? Number one, when there is jurisdictional error or action suffers from inherent lack of jurisdiction. Two, when incompetency of the authority is under challenge and such authority is improperly constituted. Three, when such action is unconstitutional and violative of the basic structure of the Constitution, and when there is patent transgression of the principles of natural justice. Ultimately, the object behind issuing this type of writs is to keep the inferior courts, subordinate courts, or tribunals, or bodies exercising judicial or quasi-judicial functions within the limits of jurisdiction assigned to them by law. And to prevent them from acting in excess of their jurisdiction. The leading cases on this aspect are AER 1955 Supreme Court 223, in this judgment, the Honorable Apex Court held certiorari can be issued for correcting an error of law apparent on the face of the record, but not an error of fact, and the court issuing a writ of certiorari acts in a supervisory jurisdiction and not appellate jurisdiction. Then one more judgment of the Honorable Supreme Court, which is quoted very often by the learned advocates. AER 1964 Supreme Court, AER 1964 Supreme Court 477. Judgment authored by the great judge, Justice Gajendra Gadkar. Syed Yaqub versus K.S. Radhakrishnan. In this judgment, Supreme Court laid down certain guidelines for issuing the writ of certiorari. Prescribed the parameters. Then coming to the fourth type of writ, the writ of prohibition. This is a writ issued to prevent a subordinate court or tribunal or administrative authority from acting or proceeding in excess of or in abuse of their jurisdiction. Then these judgments may be relevant. AER 1974 Supreme Court, AER 1974 Supreme Court 348, AER 1966 Supreme Court 1350, AER 1975 Supreme Court 2135. Repeat, AER 1975 Supreme Court 2135. The object of writ of prohibition is to confine the courts or tribunals of inferior or limited jurisdiction within their bounds. There are certain exceptions also. this writ cannot be issued to stop the investigation. AR 1990 Madras 30, AR 1990 Madras 30. In the case of Raj Leathers versus Secretary to Government of India, court said, this type of writ petition should not be issued to stall the matters which are against the interests of the country as a whole. And we should also know the similarities and the distinctions between the writ of certiorari and prohibition. In fact, these writs are similar in so many respects and are issued on similar grounds. Both are issued to prevent a subordinate court, tribunal or bodies exercising judicial and quasi-judicial functions from exceeding their jurisdiction. Then coming to the differences between these two. Writ of prohibition lies only against judicial and quasi-judicial bodies, whereas writ of certiorari lies against a public authority which acts purely in an executive or administrative capacity. Then prohibition can be issued. Another distinction is this. Prohibition can be issued before the completion of the proceedings, whereas certiorari can be issued after the decision is taken. That is, the object of prohibition is prevention, whereas certiorari is to cure by way of quashing the decision taken. Then last type of writ petition, but a writ of greatest significance, is writ of quo warranto. Writ of quo warranto. This is a powerful instrument. And this prevents the holding of public offices by the persons without any authority of law. Writ of quo warranto can be issued to oust and dislodge a person in occupation of an office without any authority of law. You may ask, what is meant by office here? Office here means a public office which must be a statutory or constitutional. Then coming to the locus standi, who can move the court? By any member of the public, and also a stranger whose motive is not improper. A bona fide person may apply. The important decision of the Honorable Apex Court on this issue is in the case of University of Mysore versus Govind Rao, reported in AR 1965, Supreme Court 491. This is broadly about various types of writ petitions. Then, incidentally, we have to see this aspect also. In writ jurisdiction, many a times we come across the well-known principle, that is, the principles of natural justice, or doctrine of audi alteram partem. That is, no one should be condemned unheard. And we should also have some knowledge about this. Essence of this doctrine is, before penalizing any individual, and when the proposed action has civil consequences, the person likely to be affected by such action is required to be heard, and fair and reasonable opportunity should be afforded. This undoubtedly helps in satisfactory decision making. You may also get a doubt. Is it applicable to the orders of the writ courts? Yes. This is applicable. This principle is applicable to the orders of the writ courts also. It is obligatory on the part of the courts to assign to give opportunity. The judgment is AAR 1967 Supreme Court, AAR 1967 Supreme Court 1269, State of Orissa versus Dr. Binapani De. Then AAR 1973 Allahabad 1, AAR 1978 Supreme Court 851, 1993 3 SCC 259, AAR 1976 Supreme Court 1785, then AAR 1980 Supreme Court 1355. But we should not forget one thing. This principle, audi alteram partem, for natural justice, is not a straight jacket formula, nor it is an absolute one. And it has certain exceptions also. Supposing, even after affording opportunity, there cannot be any change of decision, there is no scope of taking some other view, there need not be strict observance of this principle. Then incidentally, we should also know the jurisdiction of the High Courts under Article 227 of the Constitution. All of you know, Article 227 of the Constitution confers power of superintendents, High Court, over all the subordinate courts and the tribunals within their jurisdiction, both on administrative and judicial side. And this power is wider than the power under section 115 of the Code of Civil Procedure. And 1995 3 ALT 324, the scope and ambit discussed here. But one thing we should not forget. This power or jurisdiction under Article 227 of the Constitution is required to be exercised very sparingly and only in appropriate cases in order to keep the subordinate courts within their authority. Then you may get another doubt. Can this jurisdiction be exercised when there is alternative remedy? Can it be done? No. When alternative remedy is available, the aggrieved parties have to avail that alternative remedy, but not the jurisdiction of the High Court under Article 227. One question came up before the Composite High Court. of Andhra Pradesh. Wherever the value of the suit doesn't exceed 25,000, second appeal was barred by a law by the Parliament. Then, in a particular case, a suit was instituted. Aggrieved party went in appeal, first appeal. He also failed there. There, the value was less than 25,000. Since the second appeal was barred, the party filed CRP under Article 227. Then the Composite High Court said, no, this defeats the intention of the legislature, Parliament, and dismissed the revision. And another thing is, as a matter of right, it cannot be invoked. Certain important decisions are 2001, 8 SCC, 2001, 8 SCC 97. Then 2002, 1 SCC 319, 2003, 6 SCC 675, 2013, 9 SCC 221. All of you know the directive principles of state policy as contained in Part 4 are not enforceable in state law. I request all the young lawyers to make a note of certain important judgments of the Honorable Apex Court on the constitutional law, which would be really and highly helpful to all of you in your career. First one is A.K. Gopalan versus State of Madras. AER 1950, Supreme Court 27 on preventive detention. Then Walgott Tellis and others versus Bombay Municipal Corporation. AER 1986, Supreme Court. AER 1986, Supreme Court 180. Right to livelihood under Article 21 was elaborately discussed by the Honorable Supreme Court in the judgment. Then, while dealing with the action of revocation of passport without notice, one judgment was rendered by the Honorable Apex Court in Maneka Gandhi versus Union of India. AER 1978, Supreme Court 597. Then another aspect which we come across very often is whether in contractual matters writ petition lies or not. Supreme Court, Honorable Supreme Court extensively considered this issue in legal case. 2004 3 SCC 553. 2004 3 SCC 553. The Honorable Apex Court said, even in contractual matters, writs are maintainable when the action of the state is arbitrary and discriminated and affects the public interest. Then AER 2008, Supreme Court 2675. Right to property under Article 300A was discussed. The last judgment, but an important judgment, AR 1973 Supreme Court 1461, AR 1973 Supreme Court 1461. His famous Kesavananda Bharati's case. Before concluding, I request you all, especially young lawyers, let us not forget that the relief portion of the writ petition is the heart. It is the heart. It should be concise, clear and effective, and not in the form of another pleading. It should not be in the form of a pleading. This is broadly about the writ petitions, principles of natural justice, and the scope of Article 227 of the Constitution of India. Now, I respectfully request the young lawyers, budding lawyers, to interact and share your thoughts.
A few questions. What is the difference between CRP file number 115 and 227?
One question has come, rather, one brother wants to interact. What is the distinction between the jurisdiction of the courts under Article 227 and 115 of the Code of Civil Procedure? Earlier, against all the orders passed in interlocutory applications, we use it to file wherever there is no appeal provision. Revisions under Section 115 of the Code of Civil Procedure. All of you know, certain drastic amendments were made to the Code of Civil Procedure. In the year 2002. So there is an amendment made to Section 115 of the Code of Civil Procedure by adding a proviso which says, unless the order passed by the court has the effect of finally deciding the case, revision under 115 doesn't lie. Some ambiguity continued for some time. And courts in certain cases refused to entertain the revisions against the orders, interlocutory applications. Then this was set at naught by this Honorable Supreme Court. And the Honorable Supreme Court said, wherever the impact of this proviso comes, 227 can be applied. This is broadly about the jurisdiction under 227. Vis-a-vis 115 of CPC.
An employee who is outside the purview of the workman is defined under the Industrial Dispute Act 1947 got a punishment of dismissal by the District Central Cooperative Bank after following due procedure of law, that is domestic inquiry. Such an employee cannot knock the doors of the labor court and also to cooperative court, whether a writ petition seeking to issue a writ Cooperative bank. Writ petition need issue a writ of.
One question has come with regard to the maintainability of the writ petition under Article 226 of the Constitution of India. When an employee of a cooperative bank is dismissed from service, what is the remedy for him? As I said earlier, even against a private body, when there is violation of any statute, a writ lies. But there is one judgment of the Composite High Court, full-bench judgment, that is Konaseema Gramina Bank. It came in 1990. This principle was laid down, and the court also dealt with various provisions of the Shops and Establishments Act. This may also be kindly referred to. There is a mechanism under that enactment, and you will get the answer. Yes.
Under the Motor Vehicles Act 1988, under section 173 of 1, there's an award of 10,000, less than 10,000.
There is one more question. Wherever the value of the rather compensation awarded under Motor Vehicles Act may not be relevant to this, whether appeal lies or not. Appeal doesn't lie, but revisions are being entertained.
But the habeas corpus can be filed even by post by aggrieved party men when the police illegally detain them.
There is one more thing. One more question is being entertained. On a letter, whether any habeas corpus petition can be taken by the High Court under Article 226. Yes, it is being done. It's being done. Previously also we used to entertain. Yes. That will be converted as a writ petition.
What is your opinion on Article 226 of 3 and why is it?
There is one more query from one of the young Turks. What's his name?
Anonymous.
What about clause 3 of Article 226? This contingency arises when an ex parte order is granted by the court. Clause 3 of Article 226 stipulates, rather obligates, the High Courts to dispose of vacate applications within a period of 2 weeks from the date of receipt of such applications. And the clause also says, in the event of non-disposal within the set period of 2 weeks, the interim order stands vacated. Practically, in practice, what is going on is this provision is not being adhered to strictly and is continued to be treated as directory only, not mandatory, and is not being protested by the council also. Because there are certain practical problems also.
Several questions. Several questions. CRLP under 482 filed by father de facto complaint to quash a fabricated FIR is maintainable or not? Father de facto complaint is the 482 in the whether the complaint is maintainable or not, and if the complainant himself places his signature on the FIR. If the complainant himself says FIR is not signed by me, whether it is maintainable or not. The concept of public interest litigation is taking the backseat. Real social spirited citizens and advocates are finding difficult to bear the amount that has been insisted by the high courts. No doubt there's a load on the courts, but the very concept of bills are championed by Justice Krishna Iyer and Justice Bhagwati is taking backseat. That is concerning many. What is your opinion on that?
There is one query with regard to the public interest litigations. The object of entertaining public interest litigation is basically a laudable one, undoubtedly. And you know the champions of this public interest litigation, Sri Justice Krishna Iyer and Justice Bhagwati. Courts should necessarily show indulgence. To entertain such public interest litigations when they are genuine and bona fide. But in certain cases, all of you know, for the reasons known, best known to the respective persons, it is sought to be misused also. And we should be very cautious. Normally, public interest litigation, in my view, should not involve confrontation, and it should be win-to-win situation for all. And in the garb of public interest litigation, attempts are also being made sometimes, you also know, for settlement of their personal scores and interests by making the courts a stage. Sometimes they may also disturb and pose a threat to the fine balance among various organs of the state. Therefore, courts, while showing indulgence to the bona fide applications, are required to be very vigilant while exercising this jurisdiction.
Madras clarify the writ of certio rarefied mandamus. Basic research revealed that it is filed before Hon'ble Madras High Court. Can it be filed before AP High Court? Are there any other such hybrid writs?
Basically,
Certio rarefied mandamus.
there is one question with regard to Sesha rarefied mandamus. We know the field of advocacy, because I was also part of this profession for nearly 30 years. We can really enjoy this profession. And it is highly innovative also. If it is innovative, certainly it is welcome. Yes.
Whether they can file seeking to quash complaint affair under Article 226 annunciation.
There is one question as regards the quashment of FIR under Article 226 of the Constitution of India. Supreme Court, the Honorable Supreme Court clarified this issue in the year 1992 in Bhajanlal's case, where the Supreme Court said an FIR, first information report, a crime, can be quashed either under 482 of the Constitution or under Article 226 of the Constitution also. Yes.
Whether the Governor and President of India come under the writ of mandamus or not.
There is one query with regard to one aspect. Query is whether His Excellency, the Honorable President and the Governors are amenable for a writ of mandamus. Article 361 is the answer for it. There is immunity given to them.
Take over. Take over his vote of thanks. One more. When an issue has been adjudicated in proceeding under 226, Article 226, is issue unstoppable and to it. Let's dedicate applicable to same issue being part of a connected matter in the trial court proceeding and or appellate proceeding. Recently, Supreme Court has upheld 1648, so it much requires any complicated controversial questions. Those are the questions. Is there any procedure of the bill in subordinate court?
The CPC disclosure. CPC yeah. Section 91.
So do you think it's right amendment of the Constitution so far as we are concerned looking at the present scenario?
Section 91. 91.
Is personal jurisdiction confined only to presidency of high courts? Whether constructive res judicata applies to writ petitions or not.
There is a query with regard to initiating public interest litigations, whether the same is permissible under CPC, whether same can be done under the provisions of CPC. There is one provision under the Code of Civil Procedure, that is section 91. Please kindly see that. Public nuisances and other public can be curbed under that. There is one more query with regard to the maintainability of writ petitions and whether the res judicata is applicable. There is one judgment of the Composite High Court of Andhra Pradesh. When a writ petition is filed and an order is passed, second writ petition on the same cause of action doesn't lie. Another important aspect is, contextually I am saying, for enforcement of an order passed in a writ petition, whether another writ, answer is no. So Composite High Court, Andhra Pradesh High Court said it cannot be done. There is one judgment.
Further, it is maintainable against a private trust which is doing public activities.
There is one more question, query. Whether they can say private individual or a trust, writ petition can be made. The answer is AR 1989 Supreme Court. Even a private individual, when he discharges a public duty and violates the law in the said course of action, writ petition does lie.
Can state high courts stay of enforcement of foreign judgment?
CPC, section 43.
That constructive vested gain applies to the why original jurisdiction is confined to only 1993 Act. Please explain section 304A and section 304 part 2. So that's it. We'll go to accept and I'll take over and
Finally, while concluding this wonderful program, I thank one and all for extending this cooperation and for patiently hearing. Thank you. Thank you, one and all. Be safe. Stay home and be safe. Jai Hind. Jai Hind.
On behalf of the IAL, I thank Honorable Sri Justice Akula Venkata Sesha Garu, Judge High Court of AP, for being a privileged speaker on our webinar series. I thank IAL RS Sima President Garu, IAL and all the national secretaries, Muralidhar Garu, Lohit Garu, B. Pravakar Garu, and Chalsan Ajay Kumar Garu for providing the means and enabling the conduct the IAL webinar. I thank all the advocates and participants who have joined the IAL webinar and making this a grand success. Thank you, one and all.